Members, we have a quorum. I call to order the meeting of the Bills Committee on Courts Remote Hearing Bill. First, let me report something. The deadline for inviting members of the public to make submissions on the bill has expired on 6th of January. The Secretary has received a submission from the Law Society of Hong Kong, that is LC paper number CB brackets 212/2025 brackets 01. The submission has been uploaded onto the LegCo website. The Secretariat has requested that the Administration and the Judiciary Administration give a written response to the submission. I would now invite representatives of the Administration and the Judiciary Administration to come inside the conference room. On the list of follow-up actions arising from the meeting on 20th of December 2024, that is LC paper number CB brackets 218/2025 brackets 01, and the letter from the legal advisor to the administration dated 16th of December 2024, that is paper number CB brackets 21716/2024 brackets 01. The Judiciary Administration has submitted a written response, that is LC paper number CB brackets 233/2025 01. The Judiciary Administration said in the reply that an additional response will be given on the legal advisor's questions on Part 8 of the bill. The Judiciary Administration also indicated that multiple amendments will be submitted in response to the feedback given by members and the legal advisor. I will now invite Mr. Jose Yam, Deputy Judiciary Administrator, Planning and Development, Judiciary Administration, to brief members on the response, and I will ask members to press the request to speak button to indicate your intention to speak. Thank you. Mr. Jose Yam. Thank you, Chair. We will refer to the response on the specific paragraphs, and for the clauses that we have already discussed, I will go into more details, so we may jump around a little. Please excuse me on this. On paragraph 1 of the response, we are replying to the issues raised in the Senior Assistant Legal Advisor's letter dated 16th of December 2024. It is in relation to Clause 2 of the bill. We said before that it is the policy intent to restrict the scope of the bill to cover only the courts of the Hong Kong Special Administrative Region, courts and tribunals of Hong Kong, but it would not include other statutory tribunals such as the Copyright Tribunal and the Market Misconduct Tribunal. Therefore, they were not included in the definition of court. Paragraph 2. As regards the suggestion of adding the reference to Clause 7 brackets 3 in the proposed definition of remote hearing order under Clause 2 of the bill, we accept this. We will propose committee stage amendment CSAs for the addition. If you allow, I'll now jump to paragraph 20 because it also relates to Clause 2 of the bill. Paragraph 20 relates to what members talked about last time. As a general principle, means is used when the stipulated meaning of a definition is expressed in a complete and exhaustive form, whereas includes is used when the stipulated meaning is not exhaustive and only part of the intended meaning is expressed. For a definition starting with means in the first part and followed by a second part that starts with includes, the second part is intended to remove any doubt that may arise from the meaning expressed in the first part of the definition. On this principle, we have reviewed the definition of relevant terms under Clause 2 and consider them in line with the aforementioned principle. Hence, no amendment is considered necessary at this juncture. Paragraph 21. At the last meeting, members raised the issue that the definition of legal representative on subclause D, we will consider making CSAs to take out subclause D from the definition of legal representative and suitably subsume it under the definition of participant. This is in response to members' feedback. The amendment. Paragraph 22. Regarding subclause AV, in the definition of participant, the persons covered include, for instance, a person who has specialized knowledge or experience of a particular subject appointed under Section 9(4) of the Lands Tribunal Ordinance, Chapter 17, to assist the Lands Tribunal in a proceeding. Another example is assessors whom the Court of First Instance may call to its aid in civil proceedings under Section 53 of the High Court Ordinance, Chapter 4. Taking into account members' comments, we agree that it is not necessary to retain an officer, the reference, and will propose CSAs accordingly. And this probably should be read with paragraph 23. As regards why the specific word appointed is used in the bill, in the English text, we believe it should be read together with the other word involved. The policy intention is to cover persons who are appointed whether by the court or otherwise in a proceeding under a set of procedure to advise on any matter in relation to the proceeding. Other than formal appointment, there may be other forms of involvement such as call to aid, as I mentioned earlier. That is in Section 53 of the High Court Ordinance, Chapter 4. Assessors may be called to aid by the court. And in fact, for the use of the word appointed, we have made reference to other legislation, so members may rest assured in relation to the usage of the word. Let me go back to paragraph 3. Clause 4B of the bill. There were issues raised in relation to the requirement on admissibility of evidence in Chapter 503, Fugitive Offenders Ordinance. We believe it is necessary to make sure the operation is kept intact in proceedings engaging the mode of remote hearing in relation to this area. Let me now skip to paragraph 5, and this relates to clause 6 of the bill that was already scrutinized at the last meeting. By virtue of clause 63A1 of the bill, the court may specify the remote medium to be used for a proceeding under a remote hearing order. Remote medium includes, among others, live audio link. This response is given in response to the legal advisor's issues raised. The judiciary agrees that in general, live audio links are not appropriate and should not be adopted for criminal proceedings. Given the operational nature of the choice of remote medium and the variety of criminal proceedings, we want to have some flexibility, and we consider it more appropriate to provide the details through practice directions. Paragraph 6. Members raise some concerns on the use of the term virtual space. It refers to, in general, a computer-generated or electronically generated environment or space where the court and the participant may interact through an interface. We believe virtual space should be interpreted in the technology context, which will evolve over time with the advancement of technology. We do note the concerns of members, especially Mr. Leighton Kwok. We believe it would be more helpful to court users and flexible for the court to cope with the technological advancement if elaborations and examples on virtual space are to be provided through practice directions. Senior legal advisor would like to add something, right? Members, I would like members to note that we will liaise with the administration on clause 14 on the definition of virtual space after the meeting. Should members note other points in relation to this issue, we will report to members in due course. Thank you. Okay, Mr. Yan, please proceed. Thank you. Let's go to paragraph 24. It refers to paragraph 6 above regarding virtual space. Let's move on to paragraph 25. Clause 6.1 deals with the making of remote hearing order for a proceeding, whereas 6.2 specifies that clause 6.1 does not apply to an excluded proceeding, and we should read the issues in relation to clause 6.1 and 6.2 together and clause 6.4 and 6.5 together. Clause 6.4, on the other hand, deals with the making of remote hearing order for parts of an excluded proceeding, whereas clause 6.5 confines the parts of the excluded proceeding to a witness other than a vulnerable witness, giving evidence or being examined only. And in other words, the court's powers to make remote hearing orders under clause 6.1 and 4 are two distinct powers applicable to non-excluded proceedings. Clause 6.1 refers to non-exempted or non-excluded proceedings, and clause 6.4 would refer to certain parts of excluded proceedings. It is therefore unnecessary to add references to clause 6.4 or 5 and clause 6.2. Chair. Let me now go to paragraphs 18 and 19. Because other paragraphs would refer to the provisions that had yet to be scrutinized, I suggest that we look at the relevant paragraphs when we get to the clauses. Now on paragraph 18, we do note the observations mentioned in items A and B. We will propose CSAs to follow up on the relevant observations. And it is also said in paragraph 19, it is the judiciary's plan to finalize and issue relevant practice directions and guidelines by phases for the conduct of remote hearing after the passage of the bill. All right, thank you. Senior legal advisor, anything to add? Nothing? All right. Mr. Leighton Kwok has indicated the intention to speak. Mr. Leighton Kwok.
Thank you, Chair, and I thank the administration for giving us the response only last night. In fact, it contains very detailed responses to issues raised at previous meetings. The question is, I didn't have enough time to digest the responses given that they are rather complicated. So in future, if responses are demanded of the administration, do provide them earlier. Otherwise, it's pointless if we don't have enough time to digest the content for discussion. The second point is about the letter from the Law Society. It attached a submission to the administration dated the 13th of September 2022. It is again very detailed. I've checked against your bill, and I do appreciate that you have incorporated some of the views. I have two questions now for para 3.7 of the Law Society's letter on application of fugitive order. I hope the administration can make clear its position whether it can be done under a remote hearing order or not. And the second point is about para 13 of the Law Society's submission. Talk about the competition ordinance proceedings. According to Law Society, is a bit puzzled, and the government has not given any clear response. Can the administration give us a response in relation to the point made by the Law Society on proceedings of the competition ordinance? After reading the Law Society's submission, what is the government's position? Yes, Mr. Yan, please. Thank you, Chair, and thank you, Mr. Lai, for his questions. First, I have to apologize for having submitted the paper rather late. We noted members' view, and we will try to provide papers well in advance in the future. Now, in 2022, the Law Society gave us a submission when we were putting together this bill. In fact, most of the views have been duly incorporated into our bill. In relation to para 3.7 of the submission, it is the concern of the Law Society as to how we deal with criminal proceedings. I think there was a discussion at the first meeting of the Bills Committee. So apart from the proper trial, other proceedings in a criminal trial may use remote hearing. We noted the risk associated with the criminal trial, and we've already adopted their view, and we've excluded such trials as we have already adopted their view under para 3.7. As for another paragraph that is about proceedings of the competition ordinance. Now, when we defined court last time, we've covered all levels of court under the judiciary, all sorts of tribunals and magistracies, etc. But we have stressed time and again whether a remote hearing order is appropriate for a certain case. The court will have to consider all relevant factors, including the admissibility or reliability of evidence, etc. So we've said that for the submission of evidence, etc., for the competition tribunal, we have the view that they're not really appropriate. So we have already noted the view of the Law Society. If we do not have further views, then I will go back to the clause-by-clause scrutiny. We completed clause 6 last time when we ended. So shall we start with page C2450 of the Blue Bill, starting from clause 7. So will members who intend to speak or ask questions on the relevant clause press the request to speak button. After the introduction from the judiciary or the administration. Thank you. I suggest that members refer to paragraphs 4, 7, 8, 9, 10 of our response as well, because they are all relevant to clauses 7, 8, and 9, which we are going to examine. Clause 7. The court may invite submissions. 1. The court may, before making a remote hearing order for a proceeding under Section 6, invite the parties to the proceeding to make submissions. 2. If the court does not invite the parties to make submissions under subsection 1 before making a remote hearing order, any party to the proceeding who is dissatisfied with the order may apply to the court within a period as specified by the court to vary or revoke the order. 3. After hearing an application under subsection 2, the court may affirm, vary, or revoke the order, and may impose any condition that the court considers appropriate. 4. The court must inform the parties to the proceeding of a decision under subsection 3. Allow me to mention paragraph 4 of our reply. Now, section or clause 7.2 provides for the mechanism whereby any party to a proceeding who is dissatisfied with a remote hearing order may apply to the court within a specified period to vary or revoke the order. It remains a case management decision of the court to decide whether to direct a remote hearing for a proceeding. Now, it is the judiciary's intention that existing rules and procedure concerning appeals to the court's exercise of case management decisions should continue to apply, and parties may lodge an appeal on such decisions in accordance with the established mechanism, and therefore the bill does not provide a separate appeal mechanism in this regard. I pause here. Now, there are 3 members. Mr. Rin Kong. I will allow 4 minutes for each member first. And of course, you can have further rounds. Mr. Rin Kong. Thank you, Chair. Under Clause 7, theoretically, the court should invite parties to a proceeding to make submissions before making a remote hearing order. Now, if a remote hearing is already in progress, and then it is in the middle of a hearing that a party joins the proceeding. Now, I know this doesn't happen very often, but it does happen from time to time in both criminal and civil cases. How do you deal with such scenarios? Mr. Yam. We do appreciate that in actual operation, there are unforeseen conditions, just like the one mentioned by Ms. Kong. Whether a remote hearing mode should be used is entirely the decision of the court. Now, if there is new party to the proceeding, and if the judge is of the view that a remote hearing is still appropriate, then it will continue to do so and allow the new party to join as well. But if for whatever reasons a party believes that the case should not continue to be heard in a remote manner, then it can make submissions to the court, and the court will decide later whether the status quo should remain. And so it is for the judge to decide based on different scenarios. Thank you. Mr. Lai Tung Kwok. Thank you. Chair. The first question relates to Clause 7.1. As mentioned by the administration, the word may is used. Given that remote hearing is a significant matter, why do you allow the court the discretion to invite parties to make submissions? In other words, the court may decide otherwise. And then subsection 2, 3, 4 will no longer be applicable. Can you change the word or replace the word may with must to make the following arrangements much more similar? For instance, in subsection 4, you use the word must. The court must inform the parties to the proceeding of a decision under subsection 3. So in clause 7, there are two concepts. First, you allow the court discretion. On the other hand, when there is an appeal, the court must inform the parties. So there are two different concepts. Can you consider unifying the two so as to remove some of the ambiguities under this clause? Thank you. Yes, it's a well-considered decision to introduce two concepts here. Now, for very short hearings, usually it can be dealt with on the phone. We allow an additional tool for the court to dispose of such cases in another manner in order to achieve efficiency. Now, for 3-minute hearings, usually both parties have accepted such arrangements. If we mandate the court to invite the parties to make submissions, then it will not be beneficial to efficiency. If so, the court may decide to invite submissions or not. We want to allow the court discretion. If the court hasn't invited the parties to make submissions, then under clause 7, the parties can then make a submission to the court. We have noted that this is an entirely different concept. So hopefully this will allow the court decision to discretion to decide what to do. Thank you. Ms. Maggie Chen, I do agree with section 2. That is for 15-minute hearings in chamber, for instance. And also for mention proceeding in district courts. Now, I have received complaints from the sector that they are too inefficient because for mention is just to decide when the proper hearing or the next hearing should be. So I entirely agree that the court should have the case management power to decide whether a hearing should be made. And the second question is, still under subsection 2, if any party is dissatisfied with the order, then it may apply to the court within a period specified by the court. I don't know whether in the practice direction will it be in the form of an appeal or by way of a written submission. So for the period specified by the court, for instance, the court may say that by the 10th of February, if any party has any view on my order, then you have to make known to me. But if the case is only raised in March, will the court have the discretion to extend the time limit? Usually, in the court can have the power to vary the period. So is it that once I have gone beyond the specified period, the court will may give leave or not? Or is it that once the deadline is passed, the case will not be considered? Because the court doesn't have the power to vary the specified period. This may seem complicated, but it's very important to practitioners.
Mr. Jose Yan. Thank you, Ms. Chan, for your questions. On within a specified period, we plan to handle this with practice directions to specify a period. We suggest the period to be 14 days. This was the feedback that we got during consultation. We actually had some draft practice directions, and in such document it was specified to be, the period was specified to be 14 days, and the stakeholders accepted it. We want to make sure there is a reasonable period of time for parties to make submissions. So our suggestion is that within 14 days, any party to the proceeding may make an application to the court to vary or revoke the order. But I'm sure legal practitioners like Ms. Chen would know. If detailed justifications are required, it may take more time to prepare the relevant submissions. So you may raise within 14 days that the party intends to vary or revoke the order, and you may state that the justifications will be submitted perhaps afterwards. And we have seen applications of extension made to registrars before. So we can make use of an existing mechanism to deal with these applications and later submissions of documents. Any follow-up questions? Yes, Chair. So is it the case that the court may grant extension? They have the power to do so, right? So is it possible that they can ask for a 14 plus 14 or 14 plus 21 period? I think it's important to make sure the process is just and fair. But would the court have the right to grant that? Well, here it says that it is for the party to make an application to the court within 14 days. But as said earlier, if they need more time to prepare the justifications, they may ask the court to give them more time. But the court should not only deal with the issue after an unreasonable period of time. It shouldn't allow an excessively long period for the parties to submit other information. I think we should be clear about the definition because we are using the word may here. So the court would have discretion. You have talked about the policy intent, but it is not spelled out in the bill that the court would require a reasonable period of time to be set. So what you said right now may not be binding on the courts. Is it that Ms. Kwok would like to add something? Ms. Carmen Kwok. Thank you. We do understand the members' concerns, and the drafting directions we received that in clause 32C, it says specifically that if one is to apply to vary or revoke the order, there will be specific directions. That's why in clause 7 we have adopted a more flexible approach, because different proceedings may have different circumstances. Some are simpler, some are more complex. As the Deputy Judiciary Administrator said, for certain cases, more time may be needed. As for the actual period of time, we want to make sure the bill can be implemented as soon as possible. As for the smooth running or smooth operations of the bill, it would really rely on the efforts of the court as well as legal practitioners. There is detailed scrutiny of the bill. I understand the need for that. But then we also need to have a flexible approach. It's not all clear-cut. We want to make sure the appropriate approach is adopted in actual operation. And the Judiciary Administration said earlier that they would promulgate such guidelines in the practice directions. And it is also said by the Deputy Judiciary Administrator, it is important for the party to the proceeding to make an application to the court within a specified period of time. But when there are other unforeseen circumstances, or if there are reasonable justifications for more time being required, the court would have the discretion to consider such. We hope that members can rest assured, because it is believed really any party to the proceeding should make an application to the court within a reasonable period of time. Otherwise, it would be unfair. Thank you, Ms. Yong Hua Yan. I think with any applications to be made, it has always been the case that submissions would be invited. If you do not invite submissions, it's actually kind of weird. And it is said here, why is it that we have to spell out specifically that you would be inviting submissions in the practice directions? Why do you need clause 7 in the first place? Because I don't really remember any other legislation that would say the court may invite submissions. Often this piece of the process would be included in the practice directions. But the problem is, here, while you say you may invite submissions, but you do not really spell out how things are to be dealt with when one wants to lodge an appeal, for example. So can you do it like clause 6, that one may make a relevant application if they are dissatisfied with the court's decision of a remote hearing order? Why do you need a specific section 7 on this? Why not just include it as part of clause 6? Thank you. Mr. Jose Yam. Thank you, Ms. Yong, for your questions. Clause 6 refers to the fact that the court may make a remote hearing order. As said earlier, the court may, on its own motion, make an order without any submissions being made by parties. Clause 7 refers to the case where 1. The court may, before making a remote hearing order for a proceeding, invite the parties to the proceeding to make submissions. Or when the court never invited submissions before making a remote hearing order, parties may make submissions to the court if they are dissatisfied with the order. By including this clause, it would safeguard the right of parties to make submissions. We want to make clear, one, that parties can make submissions, because if we include such in the practice directions, it will not be as clear that they have such right. As for 2, what the member asked about having an appeal mechanism included in the clause, and that is relevant if the court does not invite the parties to make submissions before making a remote hearing order. The court may invite submissions from parties if they are dissatisfied, so that would work essentially like an appeal. And it says here in subclause 3, after hearing an application, the court decides to affirm the order. And we have said in our response in paragraph 4, it is the judiciary's intention that the existing rules and procedures concerning appeals to the court's exercise of case management decisions should continue to apply, and parties may lodge an appeal on such decisions in accordance with the established mechanism. So these pieces of information should be read together. I hope this answers Ms. Young's questions. All right. Next to speak, Mr. Lai Tong Kwok. I would like to follow up the point made in relation to an appeal mechanism. While I understand the response given, I'm not a legal practitioner. I'm not sure what procedures or what mechanism you're referring to. So, when parties are dissatisfied with the decision of the court or dissatisfied with certain conditions imposed, what can they do? What legal bases can they rely on when expressing their dissatisfaction? Thank you. Mr. Jose Yam. As mentioned before, the court's decision to have a remote hearing is a case management decision. It relates to the court's exercise of powers in relation to case management. And the courts have been making case management decisions almost daily. And of course, parties may be dissatisfied with the decisions made by the court on occasions, and parties may lodge an appeal on case management decisions. This is a mechanism in the legal system. And let me say again, remote hearing orders made are decisions of case management, and parties may make use of the existing appeal mechanism to deal with their dissatisfaction in relation to case management decisions. Sorry, I have some follow-up questions. Mr. Jose Yam talked about the established mechanism, that there is an established mechanism, but I want to ask, what is the legal basis for the established mechanism? Can you quote specific sections in legislation? Thank you. Mr. Jose Yam, for civil proceedings on an appeal mechanism, it will be interlocutory applications. So whenever one lodges an appeal, one would have to apply for a leave to appeal from a court, and then they can lodge an appeal. So this is what the process is in civil proceedings. In criminal proceedings, in general, parties do not have the right to appeal case management decisions. And this is a 2002 case, HKCFA judgment HKSAR and Chen Kin. And parties may lodge judicial reviews, but if it would delay the criminal proceedings, preventing the proper handling of the proceedings, the court generally wouldn't allow such. When a judgment is given, if a particular party is dissatisfied with the decision made in the judgment, that is the sentencing, for example, they would be able to lodge an appeal. So this is the difference between the civil and criminal proceedings.
Well, we have to understand that some of us are laymen in law. So, Mr. Joseph Yam, why don't you give us a written reply? You quoted some case reference too. So, if it is acceptable to Mr. Lai, now you have got an information paper for members so that they can understand the roadmap. I do understand it, but for the benefit of other members, can you please give us a written reply later? Ms. Maggie Chen, thank you. To follow up on my previous question, I'd like to ask about the actual operation of section or clause 7.2. It is said that in the practice direction, 14 days will be allowed for both parties to raise or make submissions to the court. Now, if I am the lawyer of the defendant, I did not raise a point within that 14 days, but do so on the 18th day. Will the court say that, well, we don't have the power to consider your application? Will that happen? Mr. Yam. Thank you, Ms. Chen, for your question. As explained by the law draftsman, it is not really a black and white scenario. I thank members for your respect for the court. And secondly, usually legal practitioners will operate according to court direction. So if it is clear that the period is 14 days, I'm sure parties to a proceeding know full well the time limit. Let me reiterate that we have to respect the court's position as well as efficiency. The court cannot afford to wait indefinitely for such submissions. So I hope members can all respect the time frame given in a practice direction. And for making submissions, an application can be made to the court first. If more time is required for the party to put together a submission, then still an application can be made first. Ms. Chen. Yes, because this is an important point for legal practitioners. I'd like to ask whether we do not just single out clause 7.2. Can we take into account clause 7 as well, clause 8 as well? That is, the court may vary or revoke remote hearing order. That is, even though I have not raised within 14 days, if I have only delayed for only 1 day, it will not really prejudice justice. So will you allow the court that discretion to consider such an application? Thank you. Clause 8 is really talk about clause 8.3. That is when there is a material change of circumstances. Of course, I don't rule out that in some really exceptional cases, there's a material change on the 15th day, and so the court may vary or revoke the remote hearing order. As said, we have to defer to the actual operation of the court. Thank you. Ms. Yong Hoi Yen, I'm also on clause 7.2. As mentioned, the court may invite submissions. Now, if in all cases the parties are invited to make submissions, then you don't really have 7.2, because in each and every case, the court can decide whether a remote hearing order. Now, if it is a must for the court to invite parties to make submissions, then we don't need 7.2 as well, because we have to prevent abuse. Because any party may make a submission to vary an order because there was no invitation to make submissions beforehand, and hence further delay. So we should require the court to invite submission if it makes a remote hearing order on its motion, so that you can do away with 7.2. That will be more efficient. Mr. Yam. Usually, there are proceedings such as 3-minute hearings where a remote hearing can be conducted. They're acceptable to both parties. So we want to provide an extra tool for the court to enhance efficiency where appropriate. So for 3-minute hearings, if every time the court is required to invite parties to make decisions before making a remote hearing order, that may jeopardize efficiency. So we propose to allow room for the court to decide. The court may make a remote order even before inviting submissions. Of course, under such a case, we should allow the parties to have the right to make submissions to the court under 7.2, and the court will have to consider their submissions in deciding whether the order should be affirmed, varied, or revoked. Ms. Yong. Now for 3-minute hearings, the court can just ask the two parties whether they want to make submissions. If both parties say no, we agree to a remote hearing, then there is no need to make submissions, and there will be no controversies as well. So if they agree that no submissions are to be made, that's okay, so that they don't have to come back to apply for time to vary or revoke your order, because that will be time-consuming and also costly to the client. This can prevent abuse. So if you can check with the parties to the proceeding or the client, and if they all agree, then no submissions need to be made. Even though I'm given the right to make submissions, I can decide against it. The two parties may say, well, we will forfeit our right and allow the court to decide. I hope the administrator can consider this. Mr. Yam. Thank you. Yes, I do appreciate your point. Now, if we look at the actual operation, there are quite a lot of 3-minute hearings on a daily basis. If for each and every such hearing, the court has to ask both parties whether they want to make submissions or not before making a decision, that will add to the administrative workload, because they still have to approach the parties first. The court should be able to make a remote hearing order without having to ask the parties. For most cases, both parties will agree that there is no need to make submissions. So in terms of efficiency and prevention of abuse and to allowing parties the right to make submissions, we have struck a balance, and we've noted members' views already. I'd like to follow up on the point made by Ms. Maggie Chen. And whether the time for making submissions can be extended. Now, in your practice direction, you're going to specify 14 days. The court will give every respect to what's in the practice direction. But then we have to bear in mind that there is 8.3. That is, the court has the discretion to vary the order should there be a material change of circumstances. I'd like to know whether the two are related. It's just like to apply for judicial review, the time limit is 3 minutes. 3 months. I mean, that is very clear, unless there are very strong justifications. Here, we'll talk about a material change of circumstances. Can I interpret this as a guideline for the court to exercise its discretion? Yes, you may say so, Chair, because very often the case is not really a black or white situation. At the end of the day, the court will make sure that justice is done, and that is the principle. And under that, we like to give room for the court and also parties to procedure to act accordingly. Mr. Lai Tong Kok. Now, I still have short follow-up. Under Clause 7.2, please speak into the microphone, Mr. Lai. If the court does not invite the parties to make submissions, then it has to wait at least 14 days before a remote hearing can go ahead, because it is stated in the future practice direction that 14 days will be allowed. That means the court will have to wait for at least 14 days. So for the 3-minute hearings, you cannot proceed as expeditiously as you want. So can you, in your practice direction, state that for cases where parties have not been invited to make submissions, and if there is such an application from any of them, then the submission should be made right after a remote hearing order has been made, because the current model of operation is actually counterproductive to efficiency. All right, legal advisor. Or rather, Mr. Jose Yam, please go on. Yes, I noted Mr. Lai's views. Now, in a case listings and to allow the parties to make submissions, yes, we do note Mr. Lai's view, and we will see whether we can handle this in our practice direction. Now, you mentioned para 7, 8, and 9. Would you like to follow up further on that? Para 7 of our response, as well as para 8, I think I mentioned them already. I touched on them already. Because Paris, or rather 6, 7, 8 is about the right to lodge an appeal to the original court. And as I said, both parties can handle this in accordance with the current appeal mechanism. As regards para 9, is about clauses 6 and 8. That is in response to the point raised by the legal advisor on in the interest of justice.
法公正呢個
Clause 7 did not mention in the interests of justice, and the legal advisor asked why. We addressed this question in paragraph 9. In clauses 6 or 9, the court cannot may vary or revoke a remote hearing order in clause 7, and the court would invite submissions. And under clause 8 of the bill, if there has been a material change of circumstances since the making or variation of a remote hearing, the court may affirm, vary, or revoke a remote hearing order. And it is necessary for the court to consider the factors under clause 9 of the bill, and that would be in the interests of justice to vary or revoke the order. Alright, so that has concluded our scrutiny of clause 7. Let's move on to clause 8. Thank you, Chair. Clause 8 relates to the fact that the court may vary or revoke remote hearing order. So clause 1, the court may on its own motion or on application by any party to a proceeding vary or revoke a remote hearing order. So clause 2, an order may only be varied or revoked under subsection 1 if the court, after considering the factors under section 9, is satisfied that in the circumstances of the case, it is in the interests of justice to vary or revoke the order. So clause 3, this section applies if there has been a material change of circumstances since A, the making of a remote hearing order under section 6, and if applicable, the variation of the order under section 7, or B, the variation of a remote hearing order under this section. So in paragraph 10 of our response, we have talked about for clause 8.1, we will propose CSAs because there was a suggestion that when there is a material change of circumstances, the court may also impose any condition that it considers appropriate in varying or revoking a remote hearing order. We originally intended for this, but it may not be clear in the wording. That's why we will spell it out, and we would also say that the court must inform the parties to the proceeding of such a decision. And as said in paragraph 11, whether to direct a remote hearing for a court proceeding, it is a case management decision of the court, and the court will in general provide reasons for its decisions when it informs the parties. Yes, senior legal advisor, I would like to seek clarification from the administration. And Ms. Doreen Kong said when there are multiple parties, would they, or when there are additional parties, would it be seen as a material change of circumstances and the court may vary or revoke the remote hearing order? In subclause 1 of clause 8, it says that the court may vary or revoke a remote hearing order. It is unlike in subclause 7.2 that it has to be within a period, and the period may be extended as said by the Judiciary Administration. So what is going to happen if the court is going to vary or revoke the remote hearing order? Mr. Jose Yam. Thank you. We think it is best that the court will make a decision on whether there has been a material change of circumstances. We want to make sure the court can be flexible in this regard. And we have not specified there being a period because, say, on day 15, there may be a material change of circumstances. So we think the condition should be whether there has been a material change of circumstances for the court to vary or revoke an order. But let me say this, because there are different cases in actual operation, we want to offer more flexibility for the court to make a decision in this regard. Thank you. Mr. Lai Chong-kwok. Thank you. It is said that the administration will propose CSAs in relation to Clause 8.1 to spell out the fact that the court may also impose conditions. So if you are proposing CSAs for Clause 8.1, will you also propose CSAs for 7.2 and 7.3? Because I think right now it is unclear whether the practice directions would specify that the court may impose conditions. I think it's actually clearer to include such in legislation. So would you consider proposing CSAs also for clause 7.2 and 3? Thank you. Mr. Jose Yam. Thank you, Mr. Lai, for your questions. When the court wants to vary the remote hearing order, they would be imposing conditions. So we thought the intention was clear. And I would ask the member to refer to Clause 7.3. It is said, after hearing an application under subsection 2, the court may affirm, vary, or revoke the order and may impose any condition that the court considers appropriate. So this imposition of conditions part has already been included in Clause 7. It has not been included in Clause 8, which is why we are proposing CSAs for Clause 8.1. And also in Clause 7.4, it already said the court must inform the parties to the proceeding of a decision. Again, that was not included in Clause 8. That's why we plan to propose CSAs to say specifically the court must inform the parties to the proceeding of a decision in Clause 8. Thank you. Yes, Ms. Kwok, would you like to say something? No? All right, Mr. Lam San Kung. All right, I have referred to Clause 8.3. They are actually the same in the Chinese and English texts. I misread it, so I have no other questions. All right, any other questions on Clause 8? None? Mr. Jose Yan, please move on to Clause 9. Thank you, Chair. Clause 9 is on factors to be considered. In deciding whether to make, affirm, vary, or revoke a remote hearing order for a proceeding under Section 6, 7, or 8, the court must consider the following factors if applicable. A. The nature, complexity, and urgency of the proceeding. Chair, would you like me to read out loud every one of them? And if someone requests to speak, they will press the button, but you can read them out loud slowly because members may refer to both the Chinese and English texts. All right, noted. B, the nature of the evidence intended to be adduced. C, the views of the parties. D, the ability of the parties to engage with and follow the proceeding if conducted through a remote medium. This was already mentioned when we discussed the policy issues because we need to make sure the parties had the technical capability to participate in a remote hearing. E, the personal or special circumstances of the parties, including any physical, visual, or auditory impairment, cognitive difference, and mental or psychological health issue. F, the maintenance of the rights of parties. G, whether the parties are legally represented. H. Whether the privileged communication between the parties and their respective legal representatives may be affected. I. Whether the parties and the parties' legal representatives can conduct their case effectively. J. The measures to be taken to ensure that evidence is given freely without coercion or other influence. K. The potential impact of the order on the assessment of the credibility of witnesses and the reliability of the evidence presented. L. Whether the use of the remote medium is likely to promote fair and efficient disposal of the proceeding. M. Whether the right to a fair trial can be effectively maintained. And the quality and security of the remote hearing facilities and their availability to the parties. O. Whether there is any public order, security, public health, or emergency concern that makes it undesirable or impracticable for the parties to attend the proceeding in person. P. It is like a catch-all provision. It says any other relevant considerations. As we said before in our discussion on policy issues, we hope to have a catch-all provision, and we have included all explicitly the factors that we consider to be quite relevant. And then we have a catch-all provision in P to catch anything that is not explicitly spelled out in the former part of the clause. Right, I want to ask about how, if there has been a material change of circumstances, you may vary or revoke a remote hearing order. And you have now P as a catch-all provision, but would you consider a material change of circumstances to be one of the factors to be considered that you should spell out in the bill? Because I believe that is definitely a relevant factor. Mr. Jose Yan. Thank you for the chairman's suggestions. In Clause 8, we have included a part with there being a material change of circumstances. The court has to handle the case in a particular manner. That's why we've spelled it out in Clause 8. And as said by the chairman, in Clause 9, we have said specifically in deciding whether to make, affirm, vary, or revoke a remote hearing order, the court must consider the factors in Clause 9. While Clause 8 and 9 are related, but we consider there is really no such need to spell out explicitly the material change of circumstances factor. We also have a catch-all provision in P, but I'll let Ms. Carmen Kwok to give supplementary information. Ms. Carmen Kwok. Thank you. In fact, we have the part on a material change of circumstances. It is a test that is often seen in legislation. In Clause 9, it is not necessarily tests to be included. It's just what factors the court must consider in deciding whether to make, affirm, vary, or revoke a remote hearing order. So in drafting, as the Deputy Judiciary Administrator said, we are basically giving a framework for the courts and the relevant parties to know what factors the court must consider in deciding whether to make a firm, vary, or revoke a remote hearing order in the interests of justice. And as the chairman said before, this is a very important factor to consider. And we ought to read clauses 8 and 9 together, because this follows what is said in clause 8. If the court is to vary an order, and in that process, what factors are to be considered. So the order may be affirmed or varied, or there may be additional conditions imposed. There are many unforeseen circumstances. That's why we want to have something that we are trying to spell out the factors that we have had reference to, the factors to be considered in judgments of the EU Human Rights Council. We have also referred to the law in the UK and New Zealand, and they had much shorter lists. We have the longer list of factors to be considered here. So we believe the court would have a pretty good list of factors to be considered.
Is my understanding correct? Under 8.3, when there has been material change in the circumstances of the case, then a trigger of the court to consider the factors listed in 9. That is, in deciding whether to make a firm, vary, or revoke a remote hearing order. There's been a remote, or rather a material change of circumstances, and before making a decision, the court will have to consider the list of factors listed in 9. Am I correct? Yes, your understanding is correct. So this is a guiding principle for the court to consider in making or affirm, varying, or revoking a remote hearing order. Mr. Lai. Para 9 is framed very strictly in deciding whether to make, affirm, vary, or revoke a remote hearing order for proceeding under Section 6, 7, or 8. The court must consider the following factors. Is my understanding correct? So all the factors from A to P, the court has to consider each and every of these before making a decision. Is my understanding correct? Mr. Jose Yam. Well, we do have the two words in bracket, if applicable. If under certain circumstance, a certain factor is not applicable, then the court doesn't have to consider that factor. So there is a flexibility built in for the court. All right. Then let's look at C, the views of the parties. Can you quote an example? Under what circumstance will the court not required to consider the views of the parties? Mr. Yam. In general, the court, of course, have to consider the views of the parties. If there is a particular party that hasn't make a submission or make any comments, then the view is non-existent. So this factor will not apply. We try to be as exhaustive as possible, but we do understand that under some cases, the factor may not be appropriate. Then can we go back to clause 7? The court may invite submissions under Section 6. In other words, the court is not required to do this. It's not mandated to do that. But then, will this be in contradiction with clause 9? If the court hasn't asked, how can there be views of the parties? So the two are contradictory. Mr. Yam. Yes, I got Mr. Lai's view. Now, our policy intent, as explained, is to allow the court to make a remote hearing order on its own motion. But the court may or can invite submissions. Perhaps the law draftsman can supplement later. Now, when a court makes a remote hearing order, it has to consider these factors. And of course, there is see here the views of the parties. If the parties have not made any submissions, perhaps because they don't have any particular views, and so the court can still make that order. This is a textual issue. Can I invite Ms. Kwok to supplement? Yes, law draftsman, Ms. Kwok. Thank you, Mr. Lai, for your views. Now we are going to cover a wide variety of proceedings. There are proceedings where it should be predominantly conducted in a remote manner, such as 3-minute hearings. So it's basically a remote hearing already. Whether an order has been made will depend on the actual circumstances. The views of the parties, whether we're talking about we're looking from a human rights perspective or for the interest of justice, this point should be included in the list. As regards how the court can consider the views of the parties. Now, there are different modes of communication between the court and the legal practitioners. It can be by means of writing or other forms of communication before the proper trial. Sometimes the parties may just come forward and say right from the beginning that we want a remote hearing. So in putting such arrangements into our statute, we do not want to impact on the current operation and also the means or the mode of communication between the court and the parties. For instance, the two parties may already decided beforehand that now we are going to conduct, we want a remote hearing at a particular law firm, etc. But a way of drafting, in fact, the views we received is not to change the current mode of operation. As far as possible, we should only lay down the broad principles in the court. Now, we know the guiding principle is this is purely a case management decision of the court. So we understand that legal practitioners here are to defend the best interests of the client. So this list is included, and the factors have to be considered if applicable. And the list is not just for remote hearing orders. For matrimonial proceedings, for instance, we have a list of factors for the court to decide whether this arrangement is in the best interest of the child, etc. There can be different possibilities in different circumstances. But we need such possibilities to make the system work. The bill should provide a broad framework. The legal sector as well as the court would like to have remote hearings. So please understand that the judge will have his ways of consideration. And if no formal submissions are required, we should trust that the court knows how to act in the interest of justice. But of course, there is also clause 7 and 9, and under clause 8, if there has been a material change of the circumstances, then there is a way to challenge the order. We understand what the current mode of operation is. The bill intends to reflect the current operation. Now, I believe the public would like to know or to understand the whole operation. Now you say here that the court must consider the following factors if applicable. If applicable qualifies the word must. It gives discretion to the court already. If all the factors have to be considered, if each and every one of them has to be considered, then the court must consider all of them. It would operate like a checklist for the court to take against. There is no option for the court. But here you're not saying A and B and C and O. Well, when Ms. Kwok and Mr. Yam were explaining the case, I've thought of these scenarios. Now, the court will have to consider all these factors if they are applicable or relevant. If, for instance, the mental health or psychological health of the parties are not involved, then this will not be applicable. So all the court need to do is to find out the relevant factors in the list. Is my understanding correct? Yes, you're correct. They've just read out a list. There are possible factors for the court to consider so that we won't miss out any. And they have also a catch-all point. Any other relevant considerations? Now I will give time to Ms. Maggie Chen. Are you on the same point, please? Yes, thank you. I agree. I tend to agree with Mr. Lai. In particular, he represents the view of a layman. We have to take into account the understanding of the public, but we also need such a list for our legal sector to go by. However, I have a suggestion here. I'd like to ask whether in the practice directions to advise parties to the proceedings to submit a joint letter to the court as soon as possible to state whether a remote hearing is appropriate. If it is not appropriate, then the factors should be included so that the court can consider well ahead and no formal application is required. And so the views of the parties under 9C can be included. And the second suggestion is it will not be too troublesome for legal practitioners. Whether a remote hearing will be conducted should be made known well beforehand for benefit, and that will facilitate the handling of documents. Now, a CMC this is like case management conference and also a checklist review hearing for personal injuries. These are guidelines. So there is a checklist for the parties to take against. So the parties can take whether a remote hearing is preferred. Then the court will know well beforehand the views or preference of the parties. So this is point number one.
The second point I would like to make is that I would agree with what the chairman said. We have a catch-all provision in P. While we do want to afford flexibility to the court, we have to make sure justice is seen to be done. So I suggest that we can make reference to an appeal mechanism in the UK for appealing against remote hearing orders. There is a landmark case. Sorry, I can't really find a tab. B. Children 2020 EWCACIP 584. And it says, in particular, for the case, a core value is that I would want to say in English.
咁所以變咗中文或者翻返去我哋香港呢，我希望能夠。
So I would say this. We need to ensure fairness. We also need to ensure it is just, especially in relation to the making of remote hearing orders. Thank you, Mr. Jose Yang. Thank you, Chair. Thank you, Ms. Chan, for your suggestions. We are always open to suggestions to enhance the relevant process. We hope that with the implementation of remote hearing arrangements, it will enhance efficiency, not just for the court, but also for legal practitioners. As for whether a joint letter will be required for the submissions, or whether we can have some sort of a checklist, we do note suggestions and we will consider them, but the top priority would be enhancing efficiency. We have also talked about, say, in paragraph 32 and 33, we need to make sure the court is just and the court is seen to be just. We did not specify that this is limited, that is, the behavior of the judge or the conduct of the judge is only limited to physical hearings, so that should apply to remote hearings as well. Thank you, Mr. Lam Chen Singh. Thank you. I want to ask about 9C in particular. So the court would be able to make a final decision because it is a case management decision. But we, of course, have to consider the views of the parties. Clause 6 would allow the court to make a remote hearing order on its own motion. But I think whether it is on its own motion or on application by any party to a proceeding, the court should consider the views of the parties. Parties may be legally represented, so they may know about the process, but some parties are not legally represented. Say in the labor tribunal, it would often be the case that the trade union representatives or even the workers themselves would be handling the cases. So how can we make sure that these groups are aware of their rights in relation to remote hearing. For some workers, it may be the first time they are in court. They may just accept things as they are. They may not be aware of their right to speak against the imposition of a remote hearing order. We have seen in many cases at the labor tribunal, workers may be trying to recover their wages in arrears, but they may already be working new jobs. They may not have as many leave days to actually attend court. If they are aware of their right to a remote hearing, they would probably prefer remote hearings. So for parties that are not legally represented, how can you make sure they know that they have the right of choosing which option to go for? And when you talk about the court having to consider factors such as the views of the parties, if a party is for remote hearing but the other is against, how will the court decide? I think there is really no reason why one would object to a remote hearing. I don't think one will lose out by attending a remote hearing, but if a party is against a remote hearing being held, what is the court's decision likely to be? Thank you. Mr. Jose Yang, thank you, Mr. Lam, for your questions and suggestions. When we discussed the bill, we have touched on the issue. Subject to the passage of the bill, we would like to encourage courts to hold remote hearings instead of physical hearings, and if parties agree, remote hearings can be held. And the member talks about cases to be dealt with in the labor tribunal that would often involve workers. We would make sure, subject to the passage of the bill, we will tell workers by conducting promotions in the labor tribunal that they have the right to choose a remote hearing to be held, and we will also ask the relevant officers at the tribunal to make sure the relevant parties are told of this. Parties may raise objections to a remote hearing order, perhaps saying that they do not have the relevant technical capabilities or they do not know how to operate such remote hearing facilities. And the court would consider the reasons given, and the court would reach a decision that would be in the interests of justice. So we want workers to rest assured it is only when it is fair and in the interests of justice that the court would make a particular decision in relation to a remote hearing. I want to ask about paragraph 12.1. Of a document, and they have responded to a draft bill, I believe, of the current bill. So it is said that in emergencies, and on top of that, there are other circumstances. It is to offer more flexibility. But then in the blue bill, now you do not have that. So I want to make sure the administration considers it unnecessary. That's why they have deleted this part. Thank you. Mr. Jose Yang, thank you. We did consider this because we think there is a catch-all provision in P, there is no need for us to include the part other circumstances. All right, thank you, Senior Legal Advisor. Thank you. Let me first clarify something on what Mr. Lam said. The parties may apply to have a remote hearing, but they do not actually have the right to have a remote hearing held for them. The court would have the power to make a decision. Thank you. All right. That ends our discussion on Part 2. Let's move on to Part 3. Mr. Jose Yam. Thank you, Chair. Part 3, Operation of Remote Hearing, Division 1 Judges and Judicial Officers. Clause 10, Sitting by JJOs. Where a JJO conducts a remote hearing under this ordinance, the JJO is deemed, for all effects and purposes, to have satisfied the requirement under any law to be physically present at the proceeding. Simply put, that is, for remote hearings or physical hearings, the nature of the proceedings should be the same. Thank you, Chair. Any questions? None? Let's move on to Clause 11. Thank you, Chair. Clause 11. Location of JJOs in remote hearing. A JJO may conduct a remote hearing in A court premises specified in Schedule 2. Right now, we have in Schedule 2 included the addresses of various court buildings or premises. B, any other place as directed by the Chief Justice. All right. No questions? Right, please move on to Clause 12. Clause 12, Powers of JJOs. A JJO conducting a remote hearing under this ordinance has all the powers that the JJO would have if the remote hearing were a physical hearing and the participants attended the proceeding in person. Simply put, JJOs, regardless of whether the hearing is remote or physical, they have the same powers. So I would particularly want to talk about how the legal advisor has an observation on the English text for Clause 11, and we address the concerns on this clause in paragraph 18 of our response. So, for item C, Clause 12 is a conditional sentence for a hypothetical situation, and thus it is not necessary to add as before if. Thank you. If there are no questions from members, let's proceed. Thank you. Division 2 participants, Clause 13, attendance at remote hearing. Unless otherwise required by law or an order or direction of the court, a participant may attend a remote hearing at a place within or outside Hong Kong. So, a participant may attend a remote hearing at a place within or outside Hong Kong. Clause 14, consequences of failure to attend remote hearing. A participant who fails to attend a remote hearing on a date and time and at a place or virtual space in compliance with a remote hearing order is subject to the same consequences as if the remote hearing were a physical hearing. So basically, it means if one does not attend a remote hearing, one will face the same consequences as if they did not attend a physical hearing. I'll now let the legal advisor follow up on this. Thank you, Chair. I said earlier during the meeting that I will liaise with the administration to follow up on certain issues on the definition of virtual space. If it is necessary, I will report to members on this in due course. Thank you. Mr. Holden Chow, I have a question about Clause 14. So I think there are two levels to failing to attend a remote hearing. One did not attend the remote hearing on the date and time at a place specified or at the virtual space specified. So these are two cases. So if we have specified the place that will have some equipment for one to attend a remote hearing, that would be one case. But if we are talking about a virtual space, I want to clarify something. Is it the case the remote hearing order would specify that I would ask you to go to a place A to attend the remote hearing? If you tell me for some reason you can't go to place A, but then I can still access the virtual space. Sorry, I don't know the Chinese for this, but you can still go to the virtual space. For some reason, you can't go to place A to log onto the virtual space, but you can still log on to the virtual space in space B. Would one be regarded as having contravened the remote hearing order? That's what I wanted to clarify.
Before Mr. Jose Yam answers, I'd like to exercise my discretion to extend the meeting by 15 minutes. So at least we will allow all who have pressed the request to speak button to ask questions on this point first. Mr. Yam, thank you. It's true, under 6, in making such an order, the court will have to state the place for and also the virtual place, or both, for the hearing of the proceeding. Usually for parties attending a remote hearing, they have to access or to use our link to log on to the system developed by the judiciary so as to attend the virtual interface to participate in the hearing. So the parties are required to comply with this. The reason is we are quite concerned. We want to ensure that the witness can give evidence in an appropriate room or at an appropriate location, because we're worried whether the evidence has been given under coercion or under intimidation. So we will specify the place or virtual place before the hearing takes place. Of course, there may be an unforeseen circumstance, and for some reason the person cannot be at that place. Usually, the persons or party concerned will have to inform the court that he cannot be at the place at the appointed time, and so the party may propose a place for the court to consider whether it is appropriate. The court may consider appropriate, but not so by the counterparty. For instance, the party may have doubts about the reliability of the evidence to be given. That will involve varying the order. We have had a lengthy discussion on sections 6 and 7 on variation of the conditions of a remote hearing order. And of course, if the person cannot be at the appointed place at the appointed time, of course, the court will not just allow the person to be absent for no reasons. I think we have to make it clear to the public that a remote hearing enjoy the same legal status and responsibility as a physical hearing. Now, some people may think that they can do anything on cyberspace. Now, people have to understand that they have to face serious consequence if they ignore a remote hearing order. We have to make it clear to the public, because ordinarily, if you receive a court order, you dare not be absent. You cannot be absent because you have taken too much coffee or wine the night before. So we have to make it very clear. As for change of the place, now we should not allow this lightly. All legal proceedings have to be gone through. For instance, in deciding on the place of the remote hearing, we have to ensure that a witness will not be subject to unnecessary interference, and he has to give evidence on his own volition. We have even mentioned possible large and famous firms in some countries, as opposed to giving evidence at any hotel room. There must be court permission first. So it is unacceptable for the place to be altered, because before a remote hearing is conducted, the court has to ensure that the witness is not under any coercion or intimidation. There must be proper checks of the environment, because the evidence so given has legal status. And if this is an urgent application, because it's so difficult to identify or to make available that witness. If, for instance, a particular law firm has water leakage, for example, can we apply? Because even if the person is at home, he has to make an urgent application. Now, if the hearing is to be conducted tomorrow at 9 a.m., and if there is an urgent change of place, what will happen? Yes, whether we talk about a physical or remote hearing, it is serious and solemn, and we have to follow all the legal procedures. And therefore, we have to ensure that the place for the hearing must be a place acceptable to the court. And I thank the chairman for reminding us any variation must be in compliance with the legal procedures. A person cannot say lightly that he cannot attend a remote hearing. I thank the chair for reminding us this point. Of course, there can be all sorts of unforeseeable circumstances, but we will act in accordance with court procedures. If for some urgent reasons the place has to be changed, an application must be made to the court, and the court will consider whether it is an appropriate location. And it's only with the consent of all other parties concerned that the court will consider varying this condition under the hearing order. And if there is consent from all parties, and if it is really an important matter, it can be allowed. But all the normal court procedures will have to be fulfilled. Thank you. Ms. Maggie Chen. Consequences of failure to attend a remote hearing under Clause 14. Now, I have got guidelines from the court, and I've followed all the guidelines. I have already attended or logged on to the virtual space. It was okay, but for whatever reason, suddenly I cannot access the link. I'm worried I am the client, for instance, can I call the court or the clerk and tell them that now I have problem with the internet connection, but can I just register my attendance first on the phone? Please do not consider me as having failed to attend the hearing. Mr. Yam, thank you. Now, clause 14 is talk about absence with no justifications, and parties concerned have to bear the consequences. For instance, if a participant had received an order to attend a hearing, and if the participant is only made aware of the fact that he cannot attend the hearing on the day, and if the person has informed the court and acted in a very responsible manner, the court will, of course, consider the circumstance. For instance, the thing has to be fixed first, or there can be a reschedule of the hearing, so the court will make a decision if there are good justifications. Okay, thank you. Any further follow-up on clause 14? If not, then I will choose to call it a day here. We will stop at clause 14. We will not start a new clause now. So next time we will start from clause 15. Date of our next meeting is scheduled on the 21st of January, a Tuesday, from 8:30 to 10:30. So please attend the meeting on time. Thank you. Thank you for your attendance.